Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. In my previous two videos, I talked about misjoinder of parties and non-joinder of parties in a civil suit. In this video, I will be talking about presumption under the Indian Evidence Act. So let's get started. In general, facts has to be proved before the court in accordance to the principles mentioned in the Indian Evidence Act. Court does not rely on the facts unless and until it has been proved. But in certain circumstances, the court may consider certain facts even without calling for proof for them. It means court may presume certain facts. Presumption means taking things for granted. Presumption is an inference of the facts drawn on the basis of other known or proved facts. For the law of evidence, it is used to designate an inference affirmative of negative of the existence of some fact drawn by judicial tribunal by the process of probable reasoning of some matter of fact either judicially noticed or admitted or established by legal evidence to the satisfaction of the tribunal. In the case of Kumar Exports versus Sharma Carpets, it was held that a presumption is not in itself evidence but only makes a prima facie case for a party in whose benefit it exists. Presumptions are based on the principle of omnio possumentur right esse, means all acts are presumed to be rightly done. Now, there are various types of presumption. Firstly, we have presumptions of fact or natural presumption, and secondly, we have presumption of law or artificial presumption. These are also known as rebuttable or irrebuttable. So, first, let us discuss about presumption of fact or natural presumption. The presumptions which mind naturally and logically draws from the given fact without the help of any legal directions is known as a presumption of fact or a natural presumption. Now, let me give you an example here. Suppose when a stolen property recovered from the possession of someone, the inference can be drawn that either the person stole it himself or received it from a thief as stolen property. Or if a letter has been posted, the inference is that it would reach to the addressee. Now, the second type of presumption is the presumption of law or artificial presumption. Presumption of law or artificial presumptions are based on principles of law. They are obligatory and the judge cannot refuse to draw presumption. They are of basically two kinds. First, rebuttable presumptions of law, and the second is irrebuttable presumption of law. Now, let us first discuss what is a rebuttable presumption of law. These presumptions are based on the certain legal rules which are sufficient to make a prima facie case. It means under which burden of proof lies on the opposite parties. For example, a man is presumed innocent unless proven guilty, and a child born in the legal wedlock is presumed to be legitimate. Now, the second one is irrebuttable presumption of law. Irrebuttable presumption of law are conclusive proof under the law of evidence. Irrebuttable presumptions are those legal rules which are not overcome by any evidence that the fact is otherwise. For example, Section 82 of the IPC, a child under 7 years of age is immune from criminal liability, and principles of estoppel under Section 115 to Section 117 of the Indian Evidence Act. There is also a mixed presumption of law and fact, but that is not applicable under the Indian Evidence Act. Now, the next topic for discussion is may presume and shall presume. The various types of presumptions that I discussed about till now are used under the Indian Evidence Act under the expressions may presume and shall presume. Rebuttable presumptions are used as shall presume under Section 79 to 85, Section 89 and Section 105 of the Indian Evidence Act, whereas irrebuttable presumptions are used under the expression of may presume in Section 49, Section 112 and Section 113 of the Indian Evidence Act. Now, what do these two terms mean? May presume means court has discretion to presume or not to presume. In case of shall presume, court cannot exercise its discretion. It is compelled to take the facts as proved, that is, it shall have to presume the fact. But in this case, court will be at a liberty to allow the opposite party to adduce evidence to disprove the fact so presumed, and if the opposite party is successful in disproving it, the court shall not presume the fact anymore. The main point of distinction between may presume and shall presume is that in case of may presume, the court has discretion to presume the fact, and in case of shall presume, the court has to presume the fact mandatorily. Now, the Indian Evidence Act talks about presumptions from section 79 to section 90. There are various provisions regarding presumption of genuineness of certified copies or documents produced as records of evidence, gazettes, newspaper, private acts of parliament, or presumption as regards to the genuineness of statutes and law reports, and the presumption as to power of attorney, as to electronic agreements or records and signature, etc. Thank you so much for watching the video, and please subscribe to the channel for further and regular updates.